what is illegal in one country can be legal in the other country.
Shifting one part of your business to a place that has a lower tax rate isn't tax evasion or is not illegal.
What do double tax agreements achieve? Elites move offshore, then come back as investors. Is that these double tax agreements lead to double non-taxation.
As part of our continuing series of collaborations between Africa Uncensored and The Elephant, we now have a very interesting interview regarding a ruling that was made back in March, but that has implications on the way we get taxed here in Kenya versus Mauritius. A double taxation agreement, a treaty that was entered into between Kenya and Mauritius in 2012, was struck down by a court in March of this year. Now, the people behind that case, the organization behind that case, was a Tax Justice Network Africa. And here with me this afternoon to talk about it is Mr. Alvin Mosioma, the Executive Director of the Tax Justice Network Africa. Thank you. So let me start with the first question on my mind, which is, what did you like about that ruling and what didn't you like?
So let me start with what I liked most, what I liked in that ruling. I think that for the first time, there has been, I think it's the first time I'm aware of in the continent that a party has sued, in this particular case a civil society actor or a citizen has sued and won in a case involving DTAs, because the arguments that were being made, particularly in the context of the Kenyan constitution, was that citizens have no role to play when it comes to the design of economic policies. So that, I think, opened the door. When we were litigating this matter in court, what the government was saying, oh, we consulted the Association of Manufacturers, we consulted Central Bank, we consulted KRA, and for them those were the stakeholders. Our constitution is very clear about public participation, and in their particular case, those are the ones that they saw as public. That's what I liked. What I didn't like is that it did not go to the substance of the matter, because we were, in this particular case, we were building a case on two levels. One was on a technical basis, and the other was on a constitutional basis. The constitutional basis was largely about issues of public participation, issues of parliamentary ratification, and issues like that, which are very constitutional. But the more technical one, which was actually at the heart of the question about what do double tax agreements achieve, and does this treaty achieve those objectives? And in essence, a double tax agreement is supposed to ensure that a taxpayer is not paying tax twice. In the area where they're registered, in the country where they're registered as residents, and in the country where they're operating. In that sense, it's a very good tool, actually, to facilitate investment. But what we find happening many a times is that these double tax agreements lead to double non-taxation. The taxpayer, because of the jurisdictions where they have decided to be a resident, they don't pay tax there as residents, and then they don't pay tax where they are operating from. So achieving double non-taxation. And we made very, very strong arguments in our case about how the double tax agreement was going to lead to a situation where companies that are being registered in Mauritius are not necessarily Mauritian companies.
Looking at the agreement itself, some of the things that you didn't like were that the judge didn't pronounce himself on some of the technical aspects of what you were bringing before the court's purview. Now, if you were to look at that, what would be the motive, for instance, like with the tax rates that were going to be applied in Mauritius, on withholding tax and other kinds of taxes, capital gains tax as well, and other taxes would have been far, far lower. So a person like myself, if I had a business, then the incentive would be to register my company there. Yes. So aside from that being some of the technical issues that you are dealing with, what to you was the motive behind entering such a double taxation agreement? As
a layman, you look at that and say, no, this is not right, because it significantly erodes Kenyan tax base. It significantly limits Kenya's ability to tax businesses that. So why would you do that? In my own sense, there are two objectives. There are two reasoning behind that. One is that there are those that are interested to gain, that have got a very influential role in the Kenyan politics and the Kenyan decision-making systems.
So capture.
State capture. It's definitely state capture because we already, there were companies that we are aware of that in anticipation for this double tax agreement had already made public announcements that we are moving our headquarters to Mauritius or we are opening subsidiaries in Mauritius. And those are very well connected companies. Just to make a case on how the role of state capture, it is that 2 weeks, I think it was 2 or 3 weeks after the court decided to rule in our favor, the head of state was in Mauritius again, signing another agreement. So it sends you basically how much further we had unraveled. And this is again confirmed if you look at the Mauritius leaks. The cases that emerges out of that basically go to confirm how much the concept we call that concept round tripping. It's a concept where you find Kenyan business elites move offshore, then come back as investors. That gives them two advantages. If those are politically connected companies, then the ownership is in question. You don't know if a particular state is gaining a huge contract, if it's in the mining sector or in the oil sector, that the discoveries that the country. I mean, you might see the name of the company, and the company is registered in Mauritius, but you are not able to know who are actually the people behind it. So it serves them. It serves those that are in the decision-making positions that are able to make those decisions in their favor without having to be held accountable. So in my own sense, I think that was one of the major motivations, a push by the Kenyan political elite to open a backdoor for them to bring in investment into the country without having to pay the requisite taxes they're supposed to pay. That is one. And this also goes right up into, I think, some of these issues go right up into, in terms of the political ladder. The second, I think the question of capacity cannot be underrated. Who are we sending to negotiate?
And now just bringing it back to some of the local issues that have been addressed in this interview. Uhuru Kenyatta making his way back to Mauritius after the striking out of this double taxation agreement. Has the Tax Justice Network seen the treaty?
We are trying to access it. We have sent a request under the Freedom of Information Act to get access of that bill and ensure that if it passes, if it also fulfills the requirements of what the court says it should. But more important, what's going to be tricky is that, let's assume in a worst case scenario, we lose the case in the Court of Appeal, and we go up to the Constitutional, to the Supreme Court and lose. What happens in a case like that? That means that the DTAA that Kenya signed in 2014 is legitimate, and the treaty that Kenya signed in 2019 is legitimate. So you have two double tax agreements with the same country. How do you navigate in that murky water? So I think it was really unwise for the government and the state to rush this. But I think, as I said earlier, I think it was to try and avoid some kind of domino effect.
As a devil's advocate, I would say that, shifting one part of your business to a place that has a lower tax rate isn't tax evasion or is not illegal. It's actually fairly legal. What would you say to that?
I like the word you used, illegal and illegality. And the argument we make there is that societies are not only built on principles of legality. There are other principles that inform what societies are built on. You have morality, it's a very important one. There you have ethics, these are very important. These are principles that guide how society. So if you were, like John, if you were to do everything you want, basically purely based on illegal, and say, okay, I did this and there's no law that bars me from tribalism is not illegal.
Yeah.
Nepotism, you can decide and employ all your brothers, but does it make it right? Or if you go far back and say, if we used the biggest challenges we have had in history have been clothed in the illegal framework. Apartheid was a legal system. And still people challenged it. So I think that it is wrong really to boil down and say what we are doing is illegal. and that as a basis for basically justifying particular acts that are exploiting that particular gray area of legal versus illegality. Particularly, two things. One, you look at the question of capacity. If a country does not have the resources to invest in very complex international transfer pricing units, for example, that are able to capture the international transactions, companies use those weaknesses. Does that make it right? And then secondly, I think that what is illegal in one country can be legal in the other country.
So Kenya has entered into a number of double taxation agreements or treaties that you feel are lopsided. But at the same time, Kenya is gearing itself towards setting up an international financial center. Right. Isn't it counterintuitive, or is it counterintuitive, I should ask, for a country to set up double taxation agreements with countries that disadvantage it, but then also set up an international financial center whose main purpose is to attract corporates because of the kinds of lower tax rates that they would enjoy and a easier operating environment insofar as the profits are concerned?
But you see, the double tax agreement, if Kenya was to set itself as an international financial center, and then, you know, Mauritius prides itself to be the gateway through the treaty network that they have signed. That's, if you've talked to the mandarins at the Ministry of Finance when they talk of the International Financial Center, those are the models they're talking about. They're talking about the Dubais, they're talking about the Mauritiuses of this world. So basically it would mean that it's the country again positioning itself to exploit the loopholes and gaps within its neighboring countries. So it will be to the advantage of those that are coming from outside to take advantage of those double tax agreements. So that is the positioning that Kenya would take of enabling international capital to locate itself in Kenya, to take advantage of the opportunities in the region without paying taxes in those countries where they're operating, but also not collecting taxes.
As well.
Huh?
And then that same capital can withdraw itself just as easily as it came.
100% profit repatriation. Those are some of the provisions in many of these double tax agreements, also in the financial hubs. That's basically what they say. They tell you can come, put in as much as you want, take out as much, and we don't ask questions.
Now, did you hope when the judgment came out that over and above addressing himself to the technical issues that you raised in this case, that the judge might have pronounced himself within that space on some of the professionals who benefit from a system where there is a lopsided tax agreement? We're talking about bankers here, we're talking about lawyers, accountants, that network of professionals. What would you have hoped to have seen?
You should have seen, before that, you should have seen the kind of activity that came out of the accounting firms after the court ruling. There were all kinds of advisories that was trying to calm the waters and tell them, no, relax, things are not as bad as they look. We are still advising you to use Mauritius as a conduit hub to the region. There were a number of those, the Deloittes and the Thornton and others that were providing those advisory. So these companies have survived or live by large by offering those kind of services. So I think that in terms of the court ruling, I think once what that would have, the ideal scenario would have been that connecting the providers of those services to the ruling, the implications. But you see, if the court did not look at the technical aspect of that ruling, then it would have been difficult to address the providers of those technical services. Those are the two interconnected issues. So if the court would have delved deeper into the technical issues that we were raising, then the interpretation out of that would have been that these arguments that are providing a basis for the erosion of the Kenyan tax base, the provision of those are also illegal.
Okay. All right, Mr. Mosioma, thank you very much. I appreciate it.
Thank you very much.
Thank you.